right, so my name is Liz Smith. Thanks for joining us. And this evening, I will introduce myself and tell you a little bit about Liz Smith Law. And then I'll ask if there's anything that you'd like to share specifically about yourself. Then we'll cover what will happen to your stuff when you die. That's going to include what the state's plan is for you. If you don't have a plan, the state's going to have a plan for you. So I'll do that as I have to do it somewhat generally. And then we'll talk about probate, what that is, cover different planning tools such as a will, a living trust, and other documents. We'll talk about incapacity planning if you cannot make your own healthcare or financial decisions, how to make sure someone can do that for you. We'll cover some free tools. I'll share my 2 cents about when you should talk to a lawyer, and then I'll open it up for your questions. Someone asked if the chat is savable. I believe that I get a separate file with the chat, if that's something. And then, oh, you were thinking links, probably. We can also send you, we have a separate document with links, or can send you what you're interested in. All right, so again, my name is Liz Smith. I moved to Juneau in 2005 with my now husband. A couple of years later, I left to attend law school in Vermont, returning in 2010 and working for the state. I worked mainly at the public defender's office and then also for the Department of Law. After nearly 10 years, I knew that I was ready for a change. Attorneys work a lot in conflict, but that part is not fun, at least for me. And I knew that I wanted to work with people in more of a personal capacity than I was at the state. And I had started health coaching. This was in 2017. I started a health coaching business on the side and realized how much I loved working with individuals on their particular health goals and to achieve things that they were struggling with. I also love the business side of things, and I thought that running a business would suit me really well. I was right. However, private practice in the legal world was not something I was remotely interested in. And so I knew that if I was going to start my own practice, that I was going to be very conscientious about the decisions I made, and that I wanted to do something different in my practice. For one, I had been a client before, and I was extremely frustrated by the billable hour. When I asked a question of the attorney, I didn't know if it was going to take her 10 minutes to find the answer or 10 hours. The billable hour also puts a damper on relationship building. As a client, you don't want to ask any questions you think aren't vital to your situation, because you know that any time spent with your attorney is going to be costly. And then if your attorney starts engaging in chit chat, you might feel that they are more interested in making money than they are in actually hearing about you. I don't think this dynamic is good for attorneys or for clients. And then I also knew I wanted to be very conscious about the types of people I work with and the type of work I did. I decided pretty early on that estate planning might be a good fit. But in law school, you don't learn much about specific areas of law. So I had to start learning about estate planning. I asked my friends and family about their experience of what worked and what didn't. I have a friend whose father paid over $4,000 for his estate plan to make sure that his kids stayed out of court upon his death. And yet when he died, his kids spent multiple years in court and even had to fight with his ex-wife. My friend thought that this must be malpractice, only to ask around and learn that what the attorney did was common practice. On the contrary, my grandparents hired an attorney that they met with that attorney regularly over decades, making changes to their plan as their life's circumstances changed. They also introduced their daughter, or my aunt, to their attorney, and she would later serve as their trustee upon their incapacity and later death. This meant that my aunt knew the attorney when her parents died and had a relationship and some trust built up when she turned to the attorney for guidance in handling their estate. It went relatively quickly and smoothly, and she stayed out of court. You will see and hear more about how we do things differently, but here are some of the highlights. We only serve estate planning clients, plus post-death administration, and then I work with a select number of businesses. We do entirely flat fee billing. So if you work with us, you know ahead of time exactly what your fee is going to be. You can plan for it. and you will know that all your questions will be answered without worrying about the fee. This also means I can spend time getting to know you and your family. We also have a team and systems in place so that if someone expresses interest in working with us, we're going to make sure that you get your plan in place and that it gets signed. It's all too common for someone to start working with an attorney on their estate plan and get hung up on a decision they're struggling to make. They never sign and the attorney doesn't follow up to make sure they get it taken care of, even if something might be you might be slightly unsure about a decision. We also have systems in place to follow up after signing. We review ownership documents and beneficiaries to ensure that it makes the most sense based on your plan. And if we agree together on recommendations to make changes, we're going to follow through and make sure that those changes are made and made correctly. We also offer a free review at least every 3 years so that your plan stays up to date with your life and the law. And we have a modestly priced membership starting right now at $325 a year, providing annual review and much more. You'll hear more about our process throughout this presentation, and I invite you to ask questions at the end. So that's a bit about myself, why I started Liz Smith Law, what we do here. On a more personal note, while I work a lot, I am married. You can see my husband in a picture here. We love to travel. We have 2 lovely dogs, and triathlon is really my hobby. So the picture on the bike is my very first Ironman triathlon, and I am excited to do Ironman Alaska here in just a couple of weeks. If you would like to share anything about yourself, what brought you here, feel free to put it in the chat. You can share with everyone, or you can direct it at myself. And while you do that, I want to make clear that while I am an attorney, I am not your attorney unless we have a written engagement agreement. So the information I'm providing here is generalized. It is based on Alaska law, and then I will give you options to get more specific information to what would actually happen in your situation, but general guidance, not specific to you. All right, and why are you here today? Did you come here to get the total assurance and comfort knowing that your family would be taken care of in the way you want if something happened to you? Or did you come for the peace of mind, knowing what would happen to your assets at your death? Or maybe to find out how to make sure your family does not pay estate taxes unnecessarily? Or maybe you came to make sure that you'd be taken care of in the best way possible and that the best decisions would be made for you if you became incapacitated. These are all great reasons to be here today. You'll learn what you need to do to have the peace of mind, knowing you've made the right decisions for your family during your lifetime so that at your death, things are as easy as possible for the people you love the most. So let's dive in, and I'm going to start by talking about the state's plan for you if you died without any plan at all. That is generally going to mean probate. Probate is a court process to transfer title of assets in your name at death to whomever is going to inherit. First, someone has to come forward as personal representative or executor. If you're married, if you don't have a plan in place at all, so you don't have a will, then we're going to turn to the statute to determine who's going to serve as personal representative or executor. If you're married, your spouse has priority to serve in that role. If you're not married but have adult children, they all have equal priority. That means if they can decide amongst themselves who would serve, then that's pretty easy. If there's a disagreement, then there's going to have to be court hearings and a judge is going to decide who that would be. If you don't have adult children and you're not married, it's written into statute. It kind of goes down to different family members. So you can think about in your own family, who might that be? Is it possible people would fight over that role? Is it possible that no one would want to step up in that role? There's some chance that they would have to post a bond, and some people have trouble doing that because of their own financial situation. So then once that personal representative or executor gets appointed, they're going to handle the probate process. They're going to sell any assets that need selling, basically gather everything up and then distribute to whoever is going to inherit. With inheritance, again, if you're married, that's probably going to be your spouse, but there's some different nuances in law. So for example, if you die and your parents are alive, you're married, you have parents, you don't have any kids, your parents actually have a right to inherit some, and then your spouse gets the bulk of it, but your parents have a right to inherit. If you die and have children from a prior relationship, so you're married and have children that you had with somebody else, then your spouse is going to inherit most assets, but your children are going to have a right to inherit even if you're married at the time. So there's different types of nuances like that in terms of who would inherit, what the law says, and in terms of who's going to inherit. The time to go through the probate process before you can distribute assets to whomever is going to inherit, usually I say takes about 12 to 18 months. In theory, you might get through in 6 months, but that is typically unlikely just because there's a lot that has to happen. You have to notify creditors. It is also an entirely public process, and it's a lawsuit. So if someone is going to complain about what's happening, it's relatively easy for them to file some kind of motion or some kind of challenge. And the fact that it's public means that anybody can go look at the file and see who might inherit. The quote here, a lawsuit you file against yourself with your own money for the benefit of creditors, demonstrates that it's kind of a pain. It can be rather expensive. If you have minor children and no plan in place, then the court's going to name someone to manage the assets that your kids are going to inherit. And then when your children turn 18, they will inherit everything outright to do with as they wish. Before they turn 18, the money can still be used for the kids. It's just that they don't control it until they're 18. We're going to come back to this, but if you have a will, you get to determine who can do certain roles, but you don't avoid probate. So we'll come back to that. First, I want to say that in Alaska, you can file something with the court and not have to go through full-blown probate if certain conditions are met. And all three of these have to be met. So first, if you do not own a house or any other real property in Alaska or any other state, if the vehicles you own are worth $100,000 or less, and then if the entire value of assets is $50,000 or less. On that last bullet, the $50,000, that includes assets going through probate. So if you have retirement, life insurance with valid beneficiary designations, that's not going to be included in the $50,000 because those assets would not go through probate. So usually we're looking at bank accounts and any personal property for the most part. So if all three of these are met, then your family can get an affidavit and gather assets and distribute without starting the court process. So if you don't want to be stuck in probate, if you don't meet those three conditions, a will does not avoid probate. A fully funded living trust does. And we'll come back to what a trust is. So what about estate taxes? You may have heard of them, you may be concerned about them, also known as a death tax. Estate tax, we don't currently, all this can change, but currently Alaska does not have an estate tax. So we're only subject to the federal tax. It's a very high tax, but it's only taxed on assets of an estate after someone dies if the estate is over whatever the exemption amount is at that time of death. So currently the exemption amount is ridiculously high at over $12 million. So most of us do not have taxable estates. We're not really worried about it. It's something to monitor over time for some people because it's very likely to come back down. It's already set to sunset in 2026 and come down to about 6 million. It's still significant, but it's something to monitor. And when we look at estate tax to figure out if we want to be concerned, we are looking at all assets, all equity value, even anything that's going to pass outside of probate. So life insurance, retirement does get pulled in to this calculation. So talked about the state's plan, a bit about what would happen. So when you're thinking about different planning tools, if you want to take control and decide what you want to happen, some of the main tools available is looking at a will and a living trust. So with a will, it can keep your family out of conflict, because with a will, you decide who you want to be personal representative or executor. That can be such a gift to your family if you have multiple adult children, to just pick one so they don't have to fight about it. And then you also get to decide not just who's serving in that role, but where assets are going to go, who's dealing with certain other things. It allows you to have control. One thing I like to talk about is if you have any desire to give to charity, that's certainly not something that the law is going to do. A will is perfect if you're not going to face probate anyway based on assets to express your wishes. Could face probate. A will is important if you have minor children, to say who do you want to raise them if you're not here, and take control. Again, that can help avoid conflict. It can produce important conversations, especially between the parents, and deciding who they would want to raise their children if they couldn't, and makes things a lot easier. So what about a living trust? Briefly, a trust is an agreement. What happens with a trust is the trust ends up owning your assets. So for example, we can deed a home or secondary residence into the trust. A trust can own bank accounts. It can be beneficiary on retirement and life insurance. A living trust because the trust owns your assets, then upon your death, nothing has to go through probate that's in the trust. So we just look at the trust terms, and that means that it can happen, the distribution can happen much more quickly. It stays private. And like, for example, you don't even have to notify you as everybody that might inherit. With a will and anything going through probate, you have to notice any potential heir. With a living trust, for example, you don't. So a living trust keeps your family out of conflict and also out of court. You have even more control. I find a trust to be more flexible because everything can kind of go through a trust. So if one child might want to keep the home, for example, it's a little bit easier for them to pay out the others. And then you can ensure your children do not inherit outright at age 18. We can also do that with a will. So this is a bit either tool you create a trust for your children, and you can decide then when you want them to inherit assets and have control. And then you can limit distributions through giving to your beneficiaries in a trust. So if you want to give to somebody who is potentially going to abuse the financial resources, if they're not good with money, you can leave assets to them in a trust and have someone else control the assets for them. So for my mother was on the edge. She was doing okay when she had me. She had a job. She was maintaining, but she had been using drugs since high school. And when her parents died, she was an only child. And when she received her inheritance outright, she could do anything she wanted with it. She spiraled downhill, didn't work until she ran out of money and was in tremendous debt. And it just increased her drug use. And it's really sad. I mean, was that her choice? Yes. But what her parents could have done, and which I know she would have ultimately led to a better lifestyle for her, is they could have left money in a trust it could even be a professional corporation as trustee, and they could have required that she had a job in order to receive distributions, or required drug tests, things like that. And what that trustee, the authority they have to do limit distributions, like I mentioned, that's up to you. So you get to write that into your trust and decide what you would want. What kind of control you want to give your trustee. Another thing we can do in terms of leaving assets to a beneficiary in a trust is create asset protection. So the living trust itself is really a vehicle to avoid probate. That in and of itself does not provide asset protection for the most part. But if you leave assets to your spouse or your children in a trust, there are ways that you can leave those assets that are not going to then be subject to some of their creditors. Like if they were in a car accident, or if they have a risky career, they can have those assets protected. Now I want to turn and just cover a few kind of different hot topics for you. So one thing to think about if you do have minor children is the short term. My mentor had set up her estate plan, and she had very young kids at home, out to dinner with her husband, and she realized that if they were in a car accident on the way home, she did have her will tucked away somewhere, but everyone named in the will, all the potential guardians, were out of state. So if realistically her and her husband didn't show up at home, the babysitter would call the police, and they would have really no other option but to place the kids in some kind of foster care until they figured out what was happening. It would take a few days for the long-term guardians to get to town. And so even if her kids might be with wonderful people, they would be strangers. And she created something that we call temporary guardians, which is a legal document saying these are the local people that I want to take care of my kids if something happens to me. And we provide, we call it our kids protection plan, and make sure that those short-term guardians have that paperwork. So if they were called, they would bring it with them and then hopefully arrive on scene with the babysitter before the police were even called. We do have a free resource linked to the kids protection plan that Alex has shared in the chat, and you can create some documents yourself if you want. And then also let us know if you're interested in the kids protection plan, if you want to work with us. Community property gets pretty technical. I'm happy to say that I do have a podcast. If you go to lizsmithlaw.com, click on podcast, our most recent episode that was just released, I do talk to an accountant about community property and basis. So I'm happy to now have that as a resource for you. What I'll say about community property is brief. I just want you to identify if this is something that you should talk to someone about. So if you are married and you plan to stay married, divorce is unlikely, and you have highly appreciated assets, that means like real property that's gained multiple hundreds of $1,000s in value, or brokerage accounts, highly appreciated assets, and you own the property with your spouse, you can opt in to own it as community property. And what that would mean is that if one of you dies, one spouse dies, the survivor can sell the property and pay less capital gains tax, potentially no capital gains tax if it's sold right away. You save on tax if you own it as community property. You have to opt in to community property. That's unique to Alaska and just a handful of other states. So what about long-term care? If you're thinking, about 50% of people end up in some type of assisted living or nursing home. And I have training in what we call elder law. There are ways that you can protect assets so that if you do need long-term care, you don't lose everything to the cost of care, which is very, very expensive in Alaska. So I'll leave it there, but if that's something that you're concerned about for yourself to set up, you have to set things up at what ahead of time. 5 years is kind of a magic number. Or if you're thinking about for a parent and if you want to look at what you could do to protect some of their assets or have them talk to us, that is something that we do, and we're happy to talk to you more, of course. Okay, now what about incapacity? So any of us at any time, right? It's more likely we'll be incapacitated. Anyway, things can happen. We saw with COVID, people weren't able to make decisions for a relatively short period of time. If they were on incubation, sometimes people have shorter term comas. And then of course there's longer term like dementia. So if something happens to you and you can't make your own decisions, if you now have the mental capacity, it's very, very easy for you to find a power of attorney or find a healthcare advance directive. And there's free resources that we'll share with you, and you can make your own decisions about what you want made, what decisions you want made, and who you want to make those decisions if you can't. It'll take you a few minutes. It might be hard decisions, but a few minutes, and then get it notarized. And then that person can carry out your wishes if you're incapacitated. If you don't take the time to do that now while you have capacity and you become incapacitated, then some individual will have to go to court and be named guardian or conservator. Conservator is a lesser power to manage your finances. Guardian is full power to manage where you live, etc. So that process of guardianship it's a court process, so it takes a long period of time. The courts are very busy right now. Likely you would turn to an attorney, and that's going to cost a lot of money to go through the process. I would say at least $5,000 to $10,000 just to be named guardian. And then the guardian has to file an annual report if that guardianship lasts for a long time. So it's a pain if you don't do that. And then of course, it also, by making your own decisions, means that you're deciding who you want to make decisions for you. So if you can't make your own financial or your own healthcare decisions, who do you want to do it? If you don't make the decision now, then a court's going to have to decide who that would be. So you can decide in your own family, do you want the person that would come forward to make those decisions? Is it going to create conflict, even between a partner and parents or your adult children? So take some time or work with us to get this done. But we will share links here. Advance directive is the healthcare, power of attorney is the financial. And these are in statute and provided, you'll see in the link who they're from. And then we'll also share 5 Wishes as an organization that has a really nice form. You can get it in paper, or I think they have an online version, and they do a good job of working you through the healthcare decisions. I don't love our state's form. I use all different forms myself in terms of the documents that we use, but there's nothing wrong with the state ones. We'll get it done. And then as I start to wrap up, and we think about, we talk about passing on your assets, but if you had to choose between the people you love receiving your money, values, insights, and stories, your money or your values, insights, and stories and experiences, what would you choose? Of course, that doesn't have to be a choice, but something to think about, as I think that that's all part of planning to leave your legacy. As in part of our practice, we record interviews with our clients to share for loved ones. And I've been hearing a lot of stories lately from my colleagues that do the same thing, of clients that have died and their loved ones just finding the video so valuable. It doesn't even matter. Our clients get nervous about an interview, sharing with, talking to a camera and telling their story. But it doesn't even matter what you say for your loved ones. Just having that recording and seeing you is really powerful for many people. And then there's other ways to share as well. So my grandfather wrote out his life story, which is so valuable for us now, because I'll tell you, I did not listen carefully to the stories that he shared about his long and amazing life. So now to be able to go read it has been really valuable. There's something called Storyworth. You can gift or do it for yourself. Storyworth sends an email every week, and you can just type a paragraph, answer the question, and by the end of the year, you'll have a whole book. And the part of the subscription is that they print out a book for you. So it becomes your life. It's kind of a way to do a life story. And then we'll also, I think, have a link. I did a podcast with Nim de Swart, an Australian who has a business around life stories. And there are lots of businesses like that out there. It's becoming popular, and I think a neat thing. So as you decide what your next step is going to be, I want to share with you my thoughts on when you should talk with a lawyer or go it alone. One thing about estate planning is that we're talking about planning for your death. So you don't get feedback right away and know, which might be comforting. Your family has to deal with it, but working with an attorney can provide added assurance that the people you love stay out of court and out of conflict. Working with an attorney can be helpful if you want the people you love to have someone to turn to if something happens to you. I mentioned the story about my aunt. That was really valuable for her to know the attorney. And even before someone's died, I find I do family meetings for clients that want to do family meetings. And those have been some of the most valuable moments to share with a family and talk about what plan their parents have put into place. Sometimes it's easier to hire someone to do your estate plan if it's something that you've been thinking about for a long time, having every intention of doing it and not getting it done on your own. If you want to create a trust and avoid probate, I recommend working with an attorney as well if you're doing a trust for your children to control when they're going to inherit. There's, especially with the living trust piece, there are complexities. I have seen trusts that people get on some online yada yada, and they're simply not going to work the way that they think they will, and will probably create more havoc for the family. Unmarried couples, there's some different things we can do. Blended families, there are more advanced planning options to protect inheritance for kids from different blended families. Just some interesting things to think through, and then anything unique to your situation. With that said, there's some free resources on the Alaska Courts website. This is geared towards probate after somebody dies, but it's a great resource and could be helpful. And then Alaska Legal Services has a website as well to give you some different information. If you are in Juneau, the library also has some great free resources you could talk to them about. All right, so you heard a lot today, and I'd ask you to take a moment to consider what is most important to you. Maybe you were put at ease because you're comfortable with what would happen, or maybe you're thinking to yourself, well, I really want to provide asset protection for my children or even my spouse, or you want to make sure you're controlling how and when your children inherit. Or maybe you're thinking that you want to avoid probate, whether that's because of the time that it would take, the cost, extra added cost, or because you want to keep things private. And I'd encourage you to write it down as you're thinking about it. Keep it fresh in your mind. And then you took the first step to get educated by coming here this evening. And I want to invite you to take the next step. If you're thinking, well, what would happen in my particular situation? Would my family end up in court? Would my assets potentially be lost? If you're thinking that, I want to give you the opportunity to get answers, and that is a life and legacy planning session with me. That's a 2-hour working session, which can be done completely virtually or in person if you're in Juneau or I do travel. Let us know where you are. And we would sit one-on-one looking at what you have, and you would share family dynamics. I tell you about the law, and then together we look at what would really happen to the people you love if something happens to you. And then you tell me about what about that works for you and what doesn't. And then together in that life and legacy planning session, we would choose the estate plan that would be best for your family from a cost perspective and from an outcome perspective. So even if you think you're comfortable with what would happen, I invite you to take this step to get peace of mind, knowing that you're comfortable based on your unique circumstances. Normally, the 2-hour meeting costs $750 because it's a 2-hour working meeting. But because you're here and getting educated, and if you agree to do some homework ahead of time to gather up, write out all of your assets, which is really critically important, whether you have a plan in place or not. It's the important first step, because without that, assets could potentially be lost if something happens to you. So if you do the homework, I'm offering that meeting to you for free for being here this evening and getting educated. And then additionally, if you schedule your life and legacy planning session today, and if you decide at your meeting that you do want to work with us, I'll give you $250 off your plan. So if that's something that you're interested in, and I truly invite anyone for that opportunity, this is the link to schedule, which Alex has put in the chat, and shortly or around now, you'll also receive an email with this link. So you can schedule the 2-hour meeting with me. And if you have any questions about whether this is important for you to do right now, or if this is planning you can do on your own, I'm happy to answer those questions for you. And you can definitely sign up for the meeting at a later time. I just won't give you the $250 off of planning if you do it later. And I'm giving you the meeting for free because you're here getting educated, and then the $250 is our added incentive just to sign up today. And then it also saves us a lot of time and energy from the follow-up that we do. Now, I understand you might be planning with someone else who wasn't here this evening, and we do offer one reschedule and still give you that $250 off. We just do one because I do only have a limited number of appointments per week. And then when you book, we recommend at least 2 weeks out usually. Think of about 2 hours on average to do the inventory. That can vary a lot depending on how organized you are. And you can also schedule out much longer than 2 weeks if you would like. So before I open it up for questions, I want to go through what it's like to work with us. So you will book your appointment into our system. We'll make sure that then we get to learn from you who you're planning with, what your address is, some other details like that. And then we send out a packet in the mail, and then you fill out your inventory by paper, or we have an online version. And then we have your life and legacy planning session. So that's 2 hours. During that meeting, we start by, I spend some time getting to know you. And then we look at what would happen based on, if you have an old will, I'll review that for you. If you don't have a plan, we go through what would happen now. Only if you understand what it looks like now, do I think that you can then decide, well, what don't you like about that? What do you want to change? And then that 2 hours usually is enough time. Then if you decide you want something different, to choose your plan that fits you and your family, and for us to actually design your plan together. Sometimes we need another design meeting. Oftentimes we design your plan in the life and legacy planning session. Then we meet, if you're in Juneau, about 4 weeks later for signing. If you're out of town, we're looking at 5 or 6 weeks. Go through your plan, you sign documents, and have the start of your plan and protection. And then if you're interested, we record that legacy interview with you. We do that virtually for everybody. And then we have a third binder delivery meeting. If you are doing any type of beneficiary changes, ownership changes, we're reviewing that before your binder delivery meeting. And then it gives us time after we've scanned everything in and you actually have your binder to go through the next steps with you, such as a list of personal property and who it goes to. There's some things to do after. And then lifetime of follow-up, whether that's the free review every 3 years, or if you're part of our membership program and doing annual reviews and ongoing. Many of our clients have a legal insurance plan. These are some of the ones that I've seen and worked with. I hope that you found this interesting and helpful. I'd also love any feedback you might have. And if you think someone else should listen to this, we keep updated on the website and I do them every month or more often. Please invite them, let them know. They can, Facebook as well, of course, we put the events there, but we'd love for you to share with others. And thank you very much for coming. I will open it up for questions. Again, you can unmute yourself and ask a question. You can put questions in the chat, either to everybody or just myself or to Alex.